Just noticed the music was down the most of the time. What's up, everybody? Welcome in here. Murder Church coming through tonight. We're going to go keep on digging into this Bryan Kohberger hearing from 8 days ago, from a week ago. We're at 2 hours and 21 minutes. We're going to probably put another hour or so here. Let's keep on trucking through this. Thanks for coming in. Hit the old like ski as we approach the weekend of 420 and WrestleMania, guys. Get in here. Let's go. Share it out. Hit the like.
Let's rock.
Let's rock. Al Bundy style, my man. What's up? What's up, everybody? Thank you for coming in here. I appreciate it. Publicly Buzz Live in the house on a Thursday stream, per the usual. You know, the times on Thursday vary between 8 and 9. I never know what's going on. But I think we're going to be hitting an 8 here tonight. We're going over this Kohberger stuff for just a little bit longer. But again, we're going in currently to 2 days of awesomeness. Tomorrow night, Chris Stewart's coming through here. We're going to be having a pre-420 show. We're going to be hanging out here for YouTube for a very short amount of time on Feral Friday before we head over to kick.com/publiclybuzzed. Tomorrow night, we're doing something we've never done before. We're showing something insane. It may not be for everybody, but I hope that you stick with me and go on the journey that I'm going to take you on with Chris tomorrow. I have a lot of history and a lot of knowledge of what we're going to be kind of going into, and hopefully you enjoy it. It's very, very weird. It's very, very different, but I think it will pique your interest enough to hopefully keep you here. But then Saturday, 3 p.m. Eastern Time, we've got Jay coming through here, Jay Bronius, and Dandy Savage is coming through. Midday stream, again, a pre-420 stream. It's going to be fucking dope. It's going to be cool. We're going to be hanging on YouTube for just a moment then before we head over to kick.com/publiclybuzzed to watch Grandma's Boy, something that we could never do here on YouTube. Yo, coming through here right now, EB in the house. Ember Burns popping through, saying what's up. Hold on, let me get this in here. I can't even see it. Fix my chat feature. Boom, boom, boom. I also got to do the bells. I'm going to go ahead and hit those because I'll forget. Hold on. I've passed them up. Give me the bells. Give me them bells. Give me them bells. Give me them bells. Give me them bells. Yo, Tiff in the house. Ember in the house. Shelly in the house. Pokemon going to come through here and mod up. Really appreciate that. Jennifer J coming through here, hanging out, showing off her 19-month badge right there. Hell yeah. That's what I'm talking about. Not messing around. And Laura's hanging out back here as well. Bluebird's also hanging out, and I hope that your migraine went away, and I hope that you're doing well. Unravel also hanging out. Appreciate it. Yeah, previous episodes of going over this Kohberger stuff. I'm going to try to stay on top of this as we continue to jive, as we continue to go down the path until August, when I guess the trial will start unless something unforeseen happens. Well, actually, probably, maybe, to some folks. It's a very weird genre of something. I don't want to give it completely away yet. But I think that being Buzz Nation, being me, being Chris, it's gonna be worth your time. I think it's gonna be fun. Me and Chris are both fans. It's gonna be something. Just know that, because it's wild. It's wild. What I'm gonna show you is gonna be shocking in a lot of ways. I'm going to lurk, can't watch, but I'll be listening. Thank you, Ember. I really appreciate that. Well, let's go ahead and jump in here again. We're going to be hanging out here for just a little bit of time before we head out. Yeah, actually, hold on. I'll make this a little bit better. There we go. Hell yeah. Move the camera slightly. But yeah, let's get in here. We left off at 2 hours and 21 minutes last time, and we're going to keep on trucking forth here.
A bit about the state's position. The state has no intention of suggesting to the jury that, oh, maybe this is Mr. Kohberger's DNA. We just don't know. That is not what the state is trying to accomplish. What happened is,
excuse me,
the Idaho
Hiccup.
State Police
Hope you're
lab
feeling better,
tested
Bluebird.
this DNA, and they came up with their likelihood ratio. And that number fell within a buffer zone. And under their policy, that buffer zone, generally speaking, with a likelihood ratio, anything less than 1 suggests exclusion, greater than 1 suggests inclusion. But they had done their own internal validation studies and had found that they were getting some false positives and negatives when you're close to that 1.
Thank you, Shelly, for that share. Appreciate it. Bluebird, thank you for that share. Appreciate it.
Up
thank
to
you,
100.
guys. The Buzz Nation. the heartbeats of the Buzz Nation through the folks who were amazing. And I was on there. I've been on there spouting off many times about the Buzz Nation, about what we're doing here, and about how we're doing something just a little bit different than everybody else, quite frankly. We don't do a lot of the trendy cases here. I say that as I'm doing Kohberger, which is a very trendy case, but a lot of the times we don't fall into what is just the norm in the true crime community. We do a lot of different things, like Murder Church on the Norm, Phil Spector murder trial. I'm doing a lot of the Charles Manson, the Manson family, the murders, the Tate LaBianca stuff right now, which we're going to be going again deeper into. But yeah, the Buzz Nation thrives on the heartbeat of the people, and that is you guys. And I appreciate every bit of y'all. Thank y'all.
Policy is, if it falls within that range, 0.01 to 100, we report it as inconclusive. Not just meaning you can't, uninformative. You cannot draw one way or the other, whether it's exclusion or inclusion. And so that's what we had from the Idaho State Police when we went to the grand jury. We thought that it was important. What we were trying to portray to the grand jury was that there was the only DNA that connected Mr. Kohberger to the crime scene was on the knife sheath. But the analyst wasn't willing to just make that general statement because there was this issue, this inconclusive.
I understand it's not the state's position that DNA is or likely could be Mr. Kohberger's under the fingernails, that it's unknown people from however the victim lived her life in the hours, days before this event, and whoever was the perpetrator.
What's up, Rhea? Rhea Knightley,
clothed
welcome
in. A way
in.
that,
Uno
fingernails
Ute
didn't
12.
contact skin.
Did I butcher that? Welcome in.
I assume that's the state's position.
That is exactly correct, Your Honor. The
You know,
state's
you ate
theory here
12?
is that one would not expect the perpetrator's DNA to be under her fingernails, given the eyewitness account of what the perpetrator was wearing, the complete lack of
Gypsy
any
coming down the
defensive wounds
stairs.
on this particular victim,
Can't
the
help.
toxicology
See what Dad's
report.
doing.
All of that suggests you wouldn't anticipate this to be the perpetrator. And so we have no,
So does that mean the state's not going to present this evidence in a way that would suggest or argue that it could be Mr. Kohberger's DNA?
absolutely not, Your Honor, no. And that was part of that rather lengthy, I admit, report that was submitted on Monday was to demonstrate, when the other issue to keep in mind is the Idaho State Lab uses a different program than the True Allele program that was used by the defense experts. So the Idaho State Lab pointed us to someone else they were aware of that used the True Allele program and said, why don't you speak with him? We spoke with him, and he came back with the same result, exclusion. Nevertheless, given their policy, the ISP analyst is not willing to say he's excluded because their policy prohibits her. But the plan for the state, to the extent it addresses this, is for all of that information specific to her about the policy, and it fell within the policy, and that's why I'm saying that's what the state would present. And of course, she's open to cross-examination. Of course, the defense can put on theirs that can say, no, we can say he's excluded. The state has no plan or intention to in any way ask questions, imply, or certainly argue that this DNA belonged to the defendant. That, again, we will actually be arguing much different than that you would not anticipate the perpetrator's DNA to be under the fingernails. And so that's where that is coming from with the inconclusive data. On the issue of the statistical analysis, that we agree. I mean, we're not going to ask that question. The only kind of remaining issue we have is I think their motion specifically asked for an order excluding that question or other questions like it. I'm not a big fan of that language because it's just kind of vague and we're not entirely sure what that means, but we'll stay completely away from the population of the world or a country or a city or anything about population. That's all. Thank you.
I would just like to say, Your Honor, that I guess we're in agreement, and as in an abundance of caution, I might ask the court to issue an order just that if things change, that the state has to come to the court before even trying to present such evidence.
Thank you. It sounds like, and I'm not trying to tell either side how to present their evidence, that the state's not intending to present the fingernail evidence as somehow being inculpatory. I could see, based upon cross-examination, et cetera, the defense questioning the lab person in an attempt to maybe attack the credibility of the lab, which then may require the state to put on its rebuttal expert that it's identified as to that issue. But I think we're at this point safe, based on what you've said, that the state does not have a good faith basis to suggest that the DNA, to make an argument that the DNA could be Mr. Kohberger's, that they not do that without first talking to me outside the presence of the jury based upon what the state of the facts on the ground may be at the time. As to how you question with respect
Usually
to
it'd be
statistical
sweating in the
analysis,
basement. I have to shed the old
I guess as
hoodie
guidance,
here.
it seems to me the answer that was given to a question that the analyst kind of rejected is probably the way the state ought to approach it, but I'm not going to tell them exactly how they have to ask the question. What I will say is I will
Happy
make sure I'm
Easter,
aware of the
420,
way that it was
WrestleMania
asked,
Day,
in a
too.
way that it was
A lot going on,
concerning, and
actually.
certainly if a question is
weekend's gonna be
asked
going.
in a way that is
Get into the
concerning,
warmer
defense can
weather.
object,
I'm
and
excited for it.
I can respond accordingly. All right? All right. Next motion to eliminate is defense 12 regarding the make and model of the suspect vehicle. Oh, I'm sorry, did I miss one? Oh, you're right. Within the group I identified before was the touch DNA. I apologize.
Still in DNA.
Yeah.
Your Honor, this is
Runkle.
basically a two-part motion. One is to
Bryan
exclude the
Kohberger's
use of the
lawyer,
term
Ian
touch
Runkle.
or terms touch and contact, and the other
And you
is
don't
to
know that, but
specifically
that is
exclude
true. That is
an opinion
factual.
of Rylene Nolan regarding the sheath DNA and her conclusions as to the how, what I call the how and the sort of when of when the DNA that was determined to be on that sheath, item 1.1. And I'll start with the touch and contact language. Admittedly, that is language that has been used for a number of years in the.
Your own expert used it.
Yes, she did. And we would be fine with the court precluding her from using that term. I think what is happened in the world of DNA, having been doing these cases for unfortunately 30 years, is that there's been an evolution. And we laid that out pretty well, I think, in our papers, an evolution of DNA testing, where people started realizing the sensitivity of this methodology allows you to pick up DNA from objects that have no visible stains, like no blood, no saliva, no semen. And that led to the use of the term touch or contact, because the implication and the theory behind it was that people who touch things leave things behind, leave DNA behind. We've now moved into a world where we know that not only can people touch something and leave their DNA behind, but for instance, Mr. Nye was just standing up here. He was touching the
What's up,
podium.
ADR?
I've now placed my hands on the podium. His DNA is probably on my hands.
Welcome the hell
And
in
when I
here.
sit down and pick up my phone later, I could transfer his DNA to my phone.
Sure. but
Nobody's gonna-
It probably also include your DNA too, right?
Of course, but not always. And the problem with the use of those terms
DNA's
is that
unpredictable,
it essentially allows a conclusion to be presented through a description. And there are many, many, many ways to describe touch or contact DNA. And Ms. Nolan illustrated that in the second disclosure that was produced. And I have copies if the court does
Piece
not
of
have
good
them.
content.
If you would like to review those,
Guess
I
that'd
can
be
have
some
them
client
marked.
privilege stuff, right?
And she goes through her entire discussion of transfer, which is the question here, transfer. How does DNA transfer? And how did it transfer in this case? And she does not use the word touch in describing that process. It's not essential to the description of the process. It's not essential to the explanation of how DNA moves in the environment, because many of the things she's talking about with transfer happen with any biological fluid, not just skin cells. It happens with blood, saliva, etc. So it's essentially allowing the state to prove something, a very important fact in this case, simply by asserting
Hey, I can't even take
that
credit
the
for
term
it. Somebody in the
touch
chat
DNA,
Tuesday said it, I think.
is
Guy, what's up?
usable or acceptable in the forensic
Yo,
community.
Brooklyn.
We presented at least 3 sources that say, and these are reputable people who are publishing
Yo.
in reputable journals, saying that
Yo.
this type of language is
Brooklyn!
misleading, and it can lead to a misunderstanding of the evidence itself, because touch DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from
What's up?
a person
Tennille?
has
Am I
gotten
saying
to
that
an
one right?
object, whether that's through direct or indirect contact.
Hope so.
I assume your
If I butchered
expert's
it, I
going to
apologize.
tell the jury all that.
I'm sorry?
I assume your expert's going to tell the jury all that.
Yes, and Ms. Nolan will be telling the jury that as well as she testifies.
So what are we worried about?
What we're worried about is that it's confusing to the lay person to hear an expert use a term that is essentially a description of activity. I'm not very good at grammar, but I believe that's an adverb. And it is not one that is useful for a jury, and it will be misleading because ultimately
It's a good name.
the
It's a cool name.
experts will be discussing
You don't hear that
a
one
much
often.
broader source of what we might call contact or touch DNA, which is anything that comes from a human being, including saliva or blood. Just because you don't see it, just because you can't see a blood stain, doesn't mean it's not that stain or that area that is sampled
trim up the old
doesn't
beard.
have some other biological
I think
fluid.
I want to do
So
the
it's very
stash. I think I'm almost like,
misleading.
fuck it. I'm just going to do the stash.
And it's just not necessary. And
low cut everything else.
there's a
Not to the skin,
paper
but
that was presented
pretty
as a
low.
human factors report that was published
like
last
right
year, where the consensus, although there were 2 dissenters, is that analysts should not be using this kind of language and not proffering, and this goes to the next question, not proffering opinions about this, but that the language itself is extremely misleading. There are other ways to talk about it. Ms. Nolan rejects the term trace. That was just one expert's opinion in one article that was cited to the court. But it's very clear she doesn't need to use that term in her description of how DNA moves in the environment. So we would ask the court to prohibit her or any other witness, frankly, from using those terms in describing any DNA sample that's been collected in this case.
I haven't went that low in so many years.
As far as Ms. Nolan's
weird.
opinion, again, it goes hand in hand with this idea that touch
I
DNA
just let
or
go. I
contact
shave
DNA
like
is
every-
not
like
what
twice a
it
year.
used to be thought of. And there's a number of publications, scientific journals, where the scientists have reviewed vast quantities of scientific literature. I think I counted up over 300 articles in the 2, were reviewed by the 2 articles that were cited in the moving papers.
Shit. Talking about
that
snow. That's crazy.
say that there is really no way for a particular
Jay
analyst
Money coming through the door. He said, fuck it, kicking that shit in. What's up? Yo, Phil. What up? What up? What up? I figured out what the vacuum object is that DM saw. What is that? What's that?
in a particular lab.
I mean, I kind of get like those like small vacuums compared to like a K-bar. And like I can sort of see that. I've seen somebody compare one that sort of
to
makes sense.
determine how
What do you got?
and when DNA was placed on an object when you don't have any facts behind it. In other words, unless you see something or you know something, you have facts of the method of transfer, it's not possible. So first of all, Ms. Nolan is not qualified to offer such an opinion. It's very clear from the growing consensus in the community that transfer in and of itself, how things get places, is a separate expertise which requires separate training. And a DNA analyst working in a laboratory does not have that kind of training. And in fact, it's not really provided in the United States. There is a paradigm in Europe that is being used, but it's not been accepted or used here in the United States at this point, which is the concern from some of the experts who were on the human factors report. But Ms. Nolan is not at all qualified. If you review her CV, which was part of, I think, the first disclosure in December of last year, going through the list of courses that she's attended, none of them are specific to transfer. And in her affidavit that was supplied to the court, she discusses attending some presentations at a recent meeting where there was discussion of transfer, where some unnamed individuals disagree with this idea that it's not something that should be testified to. But I think there's that her presentation, and this is what the court has to consider.
Hold on. This guy. WrestleMania Weed Weekend. Yeah, it does have an odd shape. Super odd shape. Like the end of a vacuum though, like when it's like the narrow slit when you're like trying to get into the cracks, and it's like a longer, elongated, it's not the like super oval style. Like, I could see that looking like a K-bar knife, like with the length of it and then coming into that sharp point.
Facts presented by the state in support of their opinion is not supported by anything other than this vague statement. Well,
that movie's awesome, though.
Some people don't agree with this position.
Watch.
We don't know who those people are. The state and Ms. Nolan have presented no particular scientific articles that support her opinion. And she has presented no specific training to take her from an expert around DNA testing, which no one is suggesting she is not, to an expert on the how and the when of transfer.
It's going to be different.
In this particular case.
I'm putting it on Chris.
When you look at her
Chris
opinion,
suggested it, and I did jump all
I think
over
the
it.
court has to exclude it because it's highly speculative and it's incredibly confusing. She first states that the consensus in the community is that you cannot determine when and how DNA moves onto a particular object. She says that without any qualifications, that the science doesn't support that. She then proceeds to say the DNA on the sheath could have gotten there through indirect transfer, meaning it was not placed there by direct contact of a pan, for instance, with the object.
The Christian Bale,
and then she goes on to say, but because of two facts, the quantity and the fact that it's a single
somewhere.
source,
It's pretty here today, I guarantee you. That man's coming off a golf course.
She offers this court absolutely no information to support that. She doesn't.
Those two things.
I'm sorry?
Oh, shit. That's a shirt.
Well,
get some merch going.
Yes, those are two facts.
Ain't nothing to it but to do it.
Those facts and the meaning of the facts are relevant. We cited a number of cases that talk about
expert witnesses. You'll be here Saturday, though. J Money, Saturday, 420 show. Tomorrow's a 420 show, too, but Saturday, that's right, Mosh already knows. Saturday, 3 p.m. Eastern time, we got Jay coming in for, super rare appearance. Jay doesn't do this a lot nowadays. So I got Jay coming in for a super rare appearance on 420. He was here last 420. And then I got Dandy Savage coming in for that one. And we're going to be watching Grandma's Boy on Kick. It's going to be super fun.
Speculative opinions.
And I told Dan if he's not doing anything to come through tomorrow night.
Our position is that this opinion is so speculative and so confusing that it shouldn't be presented to the jury. In great part because Ms. Nolan does not present this court with anything to support her conclusion. She's basically saying the science says I can't do this, but I think I can. If we were in a different place where we had some articles to support her conclusion, if there were articles to support the fact that the amount of DNA or the fact that it's a single source sample is probative of that,
You beautiful
that the scientific
bastard.
principles and
Go
methods
watch
of
WrestleMania,
DNA
dude. I
testing
invited Dan,
support
but
that,
he's not coming because he
then
can't
we'd be in a
drink.
different place. But that's
We're
not
gonna
where
go
we
watch
are.
some midgets wrestle on Saturday, but man, I got a lot going on, dude. I'm starting early in the morning. I got some stuff happening. Then WrestleMania night one's that night. But
We're here with a naked opinion with
Watch
no
wrestling.
foundational facts to
I
support
know,
it,
dude.
other than Miss Nolan's training and experience.
yeah, kick.com
And while
/publicly buzzed. J Money, have you never done a Feral Friday? Dude, we go crazy on Feral Friday. We show insane stuff, dude.
Training and experience is a
I'll
relevant
get you a link.
consideration for this court. We don't even know what training and what experience she's relying on. We don't have any indication that the lab has done any studies internally about this question. We don't know what literature she's been reading. And frankly, even though she attended this meeting that was held in February, where the proceedings are online and available, she didn't bother to let the court know who spoke and what they said. So I think the reason is because she doesn't have any support for this. And it's going to be incredibly time-consuming, not only to cross-examine her, but to present evidence to rebut her opinion. And given the speculative nature and the sort of both sides of it nature, I think the court has to exclude it.
Joe Chipler's gonna be like, ah. He's gonna be like,
Your Honor, I'll start where she left off. I don't think she's accurately characterizing what the opinion that's been disclosed. Ms. Nolan did not say, I agree that the science says you should not opine on this or that you cannot opine on this. All she says is that the science does say you can't conclusively establish it. But there are factors, she lays out a lot of those factors that you can look at to decide, to indicate how it ended up there. And she's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, it was primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations and she's giving her opinion, which is going to assist the jury in reaching their conclusion because the jury's not familiar with any of these factors that she's laying out for them. So, and then as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for
if
2
your head's
decades.
hurting, Bluebird,
She's a forensic scientist. She
blame you for
specializes
dipping out.
in biology and DNA. For the last 10 years, she's been the lab manager and
Stevie?
overseeing
Coming
all of the
through
biology and DNA. That includes instructing, as indicated in her CV,
What's up,
law
Missy?
enforcement and
through here?
others on the collection of DNA.
Dude, yeah, this weekend's
What we're
gonna be
discussing is a
pretty fucking
critical component of all of that, which is how does DNA get from one place to another? She has plenty of experience to talk about that while admitting that she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say to a scientific certainty that this is in fact the case. Now, on the issue of the touch DNA and just the label itself, I don't know that I've ever litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. And she didn't just use it, she used it specifically in reference to the DNA on the knife sheath, the exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case use that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury. Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that. I don't think it's outside the bounds or intellectual capacity of a juror to understand that sometimes in particular professional fields, there are phrases used that may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it. Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert, but their own expert, they're admitting that there's something there to be cross-examined. And so if this court orders there can be no statement or no mention of touch DNA, then I think that cuts off a very legitimate line of cross-examination from the state.
Saying what's up? What's up?
I'm not particularly fond in general of prescribing phrases and words that can be used by
Really
parties
opining and
witnesses
talking
in
about
cases.
this weekend.
Think it
Tomorrow and Saturday are going to be some dope ass
just creates
streams.
the potential that you're going to have problems because people slip, and particularly when you're using phrases and words that are commonly used within the field, right? We see that all the time with the use of the term victim, right, in cases, and the Supreme Court has recently weighed in on that issue. And there's actually an ICHE instruction that deals with the use of the term victim because it's just, it's hard to police phraseology. On the other hand, if what we're talking about is an agreement that, this term may be implying something that we all agreed isn't necessarily true in all cases, I mean, we could call it
Hey, I'm going to
blueberry
get Missy
DNA
on here for
all that
Feral
matters,
Friday
right? And
soon also. Need to do that.
your experts are going to
We'll watch
explain what
something
it
fucking
means
probably dope as hell.
otherwise.
She's a legit horror
What's
fan.
the concern here? If
There's
we
one movie
say,
I
let's
want to
try
show
not to
that's
call it
going to
this,
blow your all's minds that I still need to figure out. a
other
show
than
for.
accidental violation, and now
It's
somebody's
insane.
asking for a
It's
mistrial,
absolutely
right?
insane.
I mean, that's one of my concerns.
Andrew Crimey.
In reality, that's really the state's only concern is we don't want to get in a situation where there's a word that's off limit, and because she uses it, the defense expert uses it, it slips out at one point that suddenly we have a motion for a mistrial because there was a violation of this court's order. As defense counsel mentioned, Ms. Nolan didn't rely on this word heavily much at all in her opinion, and I don't anticipate her testimony to be anything different. But if at one point in the back and forth, either with us or with the defense attorney, she slips and says the touch DNA on the knife sheath, I don't think that that's a problem, and I don't think that it's something that this court should restrict. I think both of these experts felt comfortable and wanted to use that phrase. That's why they used it. I don't think it's superfluous. I don't think they just said touch to say touch. I think to them it means something,
Missy.
and it's
That's
accurate
right.
to use it in this case with respect to the
fucking dope.
sheath. But certainly the state has no problem encouraging Miss Nolan to avoid that word to the
Yeah.
extent it's possible.
Thank you.
Thanks, Your Honor.
That's the next Saturday. That's going to be
Just a
dope.
quick,
I don't know if you want me to say it yet, but yeah, I'm going to be on Missy's.
language is
live-
important.
Missy's having a live stream. I'm just saying it. I guess I'm just saying it. Missy Mayhem is having a live stream, 4/26. I'm going to be hanging out with her, and we'll be watching her favorite movie, her favorite horror film. So it's going to be dope.
And language and science evolves and changes. Ms. Nolan and Dr. Ballard, our
And
expert,
also, I'm
are
gonna have her on here for
scientists.
Feral Friday,
They
so
present
that's gonna be
themselves
dope.
as experts. And I think that scientists should be held to a slightly different standard than the average witness. And the use of language, as this court pointed out to me early on when I first stood up here, is really, really important. And I am confident that Ms. Nolan can restrain herself from using that language, and I'm confident that all of the parties can ask questions that do not elicit that kind of information or use those words, and I would encourage the court to restrict the use of those words for this proceeding. As far as Ms. Nolan's opinion, no one is asking for certainty. Nobody expects scientific certainty. That is not our position. The question is it supported by the science that Ms. Nolan is essentially testifying about? And the answer to that is no. Her personal opinion is not science. It is a personal opinion. And if the
You're relying on a scientific report to which there were dissenters.
Yes, but the dissent was not about the content of the recommendation. The dissent was,
Oh yeah.
we don't have any options, and maybe we shouldn't be requiring trainings that are not particularly available in the United States. That is the nature of the dissent. And
But in support of the idea that this testimony shouldn't be precluded by these people.
I'm sorry, I couldn't,
But in support of the dissent, in support of
yes.
opposition to a scientific consensus that this testimony should not be presented.
That's correct, but I don't think that the court has to rely on a 100% consensus of the community. I think that the evolving understanding of the science and the scientists in this area and of the people who are actually publishing work is highly relevant to whether or not that kind of opinion is actually acceptable anymore. And I suppose that the question of admissibility might revolve around a more like a Daubert standard. But given that we have not had the opportunity to see these opinions until so recently, that was not something we were able to do.
The Supreme Court has specifically rejected the Dover standard.
Well, I'm new to Idaho law, Your Honor. That's why I suggest Daubert. But that kind of analysis, I think, is the same type of analysis that this court has to do, as sort of essentially a gatekeeper, to make sure the jury is hearing reliable evidence. And I think that if you read closely, in particular, Ms. Nolan's second disclosure, which I believe came out in February, or was given to the court in February, she lays out a whole series of things that affect transfer. She makes one statement about the quantity of DNA being higher with direct transfer, but that's not elucidated in any way, and doesn't talk in anywhere in that disclosure or any other disclosure why a
Tomorrow's
single
gonna be
source,
sick. Tomorrow night at 9.
profile
Saturday
would
at
support
3.
her
I don't know if you can do either
contention. And I
both,
think
but
because
Jay's
of
Saturday,
the complex
Chris Stewart's
nature of
tomorrow.
this,
Tomorrow night's
that
going to
we
be
can't
actually. Tomorrow
speculate
night's going to
as
be fun.
why.
Let me just say that,
It
Jay.
may make logical
be
sense, but I'm not
fucking
sure it makes
crazy,
scientific
actually.
sense to speculate.
And
which I
very,
think is what
very
we are
different.
prone to
Very
do.
one-offish.
And as I think the Idaho courts have said, the court's not supposed to substitute its judgment
It's gonna be good.
when for the expert's opinion, but to consider it in the context in which it's presented. And here, there is nothing to support her opinion, absent her assertion of training and experience. And I'll stop with that.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA. As to the use of the term touch DNA, I'm not going to preclude it. As I indicated, I think it's a discretionary matter. Their science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as
Hitler
the
wants
term
everything out
victim,
in the
there's an
trial,
instruction
though.
for, I'm not opposed to giving an instruction
And everything that they're at least trying to get motions
to
to
the jury, should that
get rid of.
term,
He's like,
come
I
out,
mean, can't they explain that
you know,
in the trial? Can't the experts explain that?
is not intending to, by use of that term or by any of
It's
the
pretty blunt.
attorneys' use of that term, making a conclusion. On the other hand, I do encourage the parties to not use the term as much as they can. I think we underestimate the intelligence and reasonableness of jurors, having presided over, I don't know, well over 100 jury trials. I think that we worry about things that they are more than competent to understand and not jump to a conclusion simply by the use of a word, particularly where there's scientific testimony around explaining what that word means in context. And so I'm not particularly worried about it. I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a counsel at least, try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage counsel to try to avoid it as much as possible. All right, now I think we're on the make and model of the suspect vehicle.
Make and model of the vehicle. Let's see what we got here. Ian Taylor coming up. Let's go.
Your Honor, this is a motion where the words do matter.
Dude, Thursdays are weird for me. Whoa, Al Bundy popped up. Thursdays are weird for me. Sometimes I start at 9. Sometimes I start at 8. I don't know. I just kind of, I put tonight at 8, but it could have been 9 even. Sometimes I'll change it before we even get to the show, but yeah, just got to keep an eye on her.
Following up on that one, this seems appropriate.
It's the one day that kind of gets
This
a little bit weird
motion,
sometimes.
we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in
Dude,
Mr.
tomorrow's gonna be fun, dude.
Kohberger's rights to due process and a fair trial.
It's going to be a good one.
Thinking of why we have this motion, we
Hear
have
what
to
they're talking about this
remember
car.
this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they
Seeking
do
Justice
not
coming
have
through.
one continuous video
Make sure you're in the
loop.
Seeking Justice Discord.
So the state's piecing together several videos
Best
and
folks,
calling
man.
them
And
all
follow 'em on
suspect
X.
vehicle number
I don't
1.
know if Pokemon's still
That
out here.
invades the province
Should
of
get
the
some links
jury
there.
to
That'd
make
be
that
amazing.
determination. The state
out
has
here killing it, though.
Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use.
Yeah, this is what I've always
That
been interested
make
in
and
and
model.
always sort of thought. I've always knew that there was going to be an insane amount of surveillance on the way and from businesses and residences. I've always thought, man, who knows what could have been picked up by the police. So I think that's going to be huge, quite frankly. And you put that in comparison with the time frames that he is alleged to have either come or gone, in comparison with when the phone would have been off, like all of this, I don't know, man. It's super interesting.
Cannot be identified from other than one view.
And what was it? I don't even remember the amount of terabytes, but it was an insane amount. So, I mean, they're talking about how they, I think Ann was even quoted as saying, like, it would take us years to, like, get through all this, which is probably true. And I think Hippler's response was something to the effect, maybe it was even in this, maybe it was the one before this, was something to the effect of, you don't have to go through all of it. You would know the time frame on these surveillance videos that you're going to be seeing, because usually that's depicted. But,
Of that.
it's interesting. It's going to be interesting.
This motion is not asking the court to prohibit the state from producing the videos or producing Agent
Yeah,
Immel
thank you so much, Shelley. Appreciate that.
insofar
Get
as
them
his
links in.
testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number 1. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number 1 has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle 1 to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
Wish I would start with, listen, bitch.
Your Honor, it is our expert opinion,
Oh, I can't
who is
put
a
those
vehicle
little
identification
but I mean,
specialist.
listen
Anthony
to
Imel.
each other.
It is his opinion
State and
that the
defense.
suspect vehicle
As I said, that it's like, oh
captured
god,
on
this is getting
various
confused as
surveillance
Hippler, and
video
Hippler's just gonna be like, all
shows
right.
similar class characteristics to a
Straight to
2014
jail.
to 2015 Hyundai Elantra. He specifically relied on certain video, while some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance and footage, including observed traffic flow, the time of night, the direction of travel,
I got
and
me
the camera timestamps.
Seques.
The jury should be allowed to hear his opinion, weigh that information
drinking,
with other
Micah?
testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014-2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Your Honor, our request
Yep.
is not at this
Yeah, like a
stage
longer
to
now.
limit Agent Immel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the
Nice,
vehicle as one vehicle in all of these clips. Agent Immel
Big Timber IPA. Dan
can
would dig that.
talk
now,
about
for
the
sure.
clips. We can view the clips with the jury,
He
and
goes
he'll be
down the
subject
IPA
to
route a lot.
cross-examination. The motion is wholly about,
We'll say that this is the same vehicle on each of the clips, that
No.
it is expertise.
no, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
Not actually factually true, as I understand it. It was expanded before the 19th.
Let me back up. The
Well,
email that I think
let's
was
see that,
disclosed in the Frank's
Shelley.
motion to the court was that he preferred a 2011 to
That's awesome.
2013 Hyundai Elantra, but open up the search through 2016.
So, Mr. Polk,
Moscow Police
you're doing
Department
good.
set out their Be on the Lookout flyer for a 2011 to 13 Elantra.
Mr.
And
Polk,
that's what was
tomorrow
sought.
night, Saturday, come through for sure. Saturday watching Grandma's Boys is gonna be super duper fun. But man, Saturday, I don't want to give it away just yet. I want it to be a surprise, but it's gonna be something crazy, completely out of left field,
For a long time.
unpredictable. I could give you a million guesses, and no one would guess it.
Agent Immel in that email did say
We would all just
expand
die.
that
We
year.
would die guessing.
The change
Well, I wouldn't, 'cause I know.
that there's a vehicle, a Hyundai Elantra, that's a 2014 to 2016
I
came
would
later,
stay, 'cause
and
I'd
that
feel
came
bad. I'd be like,
after
"Oh,
Mr.
God, I'm
Kohberger
dying
was
too," but you're
identified
still
on
guessing.
December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together
Yeah,
much
this is-
later.
And we're going to be seeing these vehicles. And I hope look, because the fucking cameras in this trial are going to be trash. Look at this. Like, they're just three. I really hope it's better than this when we actually get the trial time. Because when they're showing this, come on, are they going to be zooming in and actually showing us? Or we're going to have like a terrible off screen, like can't really tell what's going on in the surveillance because it's already terrible footage. But if we can see something, I think that's going to be very interesting, at least if the jury can see, anyways, that's all that really matters, is that the Elantra didn't have a front license plate, because in Pennsylvania you didn't need a front license plate, but in the state of Washington you did need a front license plate. And then months later, what was it, 2 weeks later, he ended up getting the front license plate. But I think in those footages, that not having the front license plate is going to hurt him, because we're going to be seeing multiple instances of these cars without a front license plate, and I feel like that would be more odd than not. And again, it lines up. And you put that with the DNA, you put that with the phone being off, and you keep just adding things on top of each other. And I think a jury is going to go the direction of convicting Bryan Kohberger.
After Mr. Kohberger's been identified, not back
It's going to be an interesting
in November
one, man.
of 2022
I think Ann Taylor's
when
good,
they're
though.
trying to identify a vehicle.
don't think that's consistent with the facts, but okay. I think the
That's
facts
the
are
bulk.
in the email. It was originally, let's look at this date range, and then he said, well, I'm more comfortable with an expanded, or we need to expand the range through 2015, and that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in two different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
Dude,
That's,
and it's been a long ass time now. It's been like freaking 2 years, but we were doing episodes on this shit, and we were looking at the years of the actual cars between 2013 to even further than 2016. They're all basically the fucking same and look very, very similar. So I could see an expert not wanting to hang his hat on a certain amount of years, but they did end up changing it and getting it into what it was with the 2015 model. Manny Joe coming through here. What's up? What are you doing?
I'm trying to explain to the court where I'm coming to my
Got
my
some fun shows
request to
coming
the
up this
court.
weekend, Mandy.
I was
Crazy one
asked
tomorrow
what
with Chris Stewart.
Agent Immel would
Saturday,
say, and
got
I'm
Jay coming on here with
repeating it to the
Dandy.
very best of my ability. The motion is not about Agent Immel's
Tina,
testimony.
what's up?
I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude, is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1, and so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
It's like, this is all I got.
Right.
They probably didn't roll on the series.
So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't it?
Imagine being Kohberger though, and like having judge before this guy, and you're already just like, man, this sucks, fuck, this isn't gonna be good. But shit, she's talking about getting out of here. Maybe this area is a little too, they know a little bit too much about the case. It's not gonna be an impartial jury. Oh shit, I kind of like this. Who knows what we might get next? And then you end up with this guy. Oh my fucking god. And that's just coming from Kohberger's perspective. I like Hippler. I think he's pretty fair, honestly. But to be in Kohberger's shoes with what we have on the table, bro.
My motion.
Yeah.
I'm just being honest. In my opinion.
I tracked there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle 1 is making a specific conclusion. It's, again, using a term that is used within the investigation, but specifically making an argument that the various vehicles, or the various images of vehicles on the various surveillance cameras is the same vehicle. Making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be, right? As to the agent's ability to make that conclusion. I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right within the province of expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes, and then we will come back. We'll shortly before 1, but no later than 1.
Like, listen. Listen, it's been a day. It's been a day and a half, son of a bitch. I'm getting out of here. Oh, boom. So we're going to be coming back at 4:07 here. As you can see, yeah, she's coming up right here from the defense side. I forget her name now. But yeah, all right. We're going to, I guess, if this stays up, we're going to keep trucking. We're about halfway through it now, which is interesting. Everybody coming through here tonight, I really appreciate it. Thanks very much. Yeah, the next time you're going to be seeing me is going to be tomorrow night with Chris Dewitt. All right? We're going to be having a good one. We're going to be having a fun time. Again, it's going to be a mystery show. Come prepared for anything. That's the only tips I could give. It's going to be very unique, very interesting. And he suggested it, and I did jump on it. I was like, you know what? Yeah. It's a unique show already. But then Saturday, 3 p.m. Eastern Time, Jay, Dandy Savage coming on here. We're going to be watching Grandma's Boy on Kick. But we will start here on YouTube both times. So, all right, everybody, kick the rest of this week's ass. Light it up rest of this evening. And then go into Friday. Tell it the let's go. Let's go. Let's get into Saturday. And it's supposed to be a good weekend. WrestleMania. All right, 420, Easter. A lot of stuff going on. A lot of things happening. So it's going to be epic. It's going to be really good. Tomorrow's going to be started off with Feral Friday right here with the Buzz Nation. I'm telling you right now, you're going to learn a thing or two about a very niche thing. I don't know if that's a good pitch or not. That might not be a good pitch. Everyone's like, what? The fucking what? All right. I'm just saying. It's going to be good. It's gonna be good. You're not gonna want to miss it. You're not gonna want to miss it. I'm just saying.
I'm telling you like it is, baby.
Just saying. Just put it out there.
Are you crazy? Are you out of your mind?
Tomorrow you may be asking yourself that.
Let's get physical.
This hurts.